Good morning. Thank you for coming. For me, it's really important that we continue to build alliances across different industries in order to better our employees and also, most importantly, I think within the sector that many of the professionals that are here are from within the health sector, we need to also pay attention to that. And for us, it's something that we really, this is kind of groundbreaking for us. We as a conference have really concentrated over the years in offering CPDs for professionals in learning more academically and clinically around addiction and associated disorders. But as we move forward and as we realise that whether or not patients or clients, those of us that work in a relational situation, whether or not it's a team member or we are working with a family or we're involved in criminal law, there are more industries that align that we maybe gave justice to before. So moving forward and being able to introduce Dr. McCann and Sarah is something that I am very passionate about. Dr. McCann, you've been writing for many years, and this is an area of expertise for over 30 years, and this is the first time that I've met, and it's an honour to meet you. I know that you're a faculty member for the Occupational Medicine Association. You're also a board member at Castle Craig. Castle Craig have been groundbreaking for years and years in what they've done, the treatment they've provided for different services, different industries, and supporting employee-assisted programs and people in the workplace that are struggling with addiction and associated disorders. Sarah, I'm really excited to have you here. I'm really excited to have the practice here. I can see that there's very many areas, extensive experience, it says here, across kind of litigation, disciplinary matters, and this is a passion of yours. So I know you've spent some time, and we really appreciate that, and bringing this together and looking at sort of three main areas with assessing and working with and finding solutions for the impact of substance misuse or substance issues within the workplace. And your latest book, which is it published already?
It was
2018.
2012.
Oh,
no,
okay.
You said it was 2018. But
Print error.
right.
Apologies for that.
Don't worry. Yeah.
But yes, so the title for that was Alcohol, Drugs and Employment. So, maybe you'll be able to tell us a little bit about that as well. If we have time. But it's a real honour to have you here and for us to keep moving forward and aligning workplace solutions. So thank you. With further ado, may I introduce them? Thank you.
Good morning. Our presentation this morning is Addiction, Corporate Risk, Human Frailty and Legal Argument. This is a joint presentation, as Sam has mentioned, between myself and Sarah. As you know, Sarah's an employment lawyer, and she will present the legal issues. As for myself, I'm a non-executive officer at Castle Craig and have written 2 books on the present subject. But what I'd like you all to do now is to pretend you're a senior executive in a large organization. Your company is doing well, shares are up, all is well. But perhaps we may introduce some doubt. Corporate risk, human frailty can lead to human error. Human error constitutes the largest cause of all workplace accidents. It was cited as the root cause of most critical accidents in recent memory. I take one example, the Bhopal gas plant disaster. 500,000 people were affected, 16,000 died, and 4,000 were permanently injured. Further 35,000 were injured but not permanently. Also, because the gas was heavier than air, children were more affected because they were lower down. So what we're talking about is an incubating crisis leading to a catastrophic event. And Professor Dennis Smith cites the sinking of the Titanic as an example of failure due to human error. He described the 7 C's. And he said, this was in his paper, The Dark Side of Excellence, Managing Strategic Failures. And he talked about the 7 C's, which I'm now going to describe in relation to the Titanic. If we look at the culture, the captain was sleeping while the vessel was speeding at 22.5 knots. That's equivalent to 26 miles per hour. The control, they were unable to take full evasive action when they saw the iceberg. They had 37 seconds from seeing the iceberg. And if you can imagine, there's 43,500 tons of boat traveling at 26 miles per hour. They needed appreciable time to miss the iceberg. Communication, the crew disregarded warnings from other ships because the Titanic was unsinkable. Rocket flares gave incorrect signals when they went up. Configuration, there was intense rivalry between the shipping companies seeking competitive edges at all cost. Coupling and complexity, the iceberg buckled the hull steel plates below the waterline, and 6 watertight compartments flooded. If only 5 had flooded, the boat would not have sunk. The cost factors, errors. Inferior steel was used and was single-hulled to save cost. But more damning of all was the contingency planning. The lifeboat numbers were reduced to 20 from the recommended 64. And this was to avoid clutter on the decks. So I want to use this 7 C's as a worked example for an accident at the New York subway in 1991. I'm going to use the example here. I'll briefly tell you about what happened. The driver was an alcoholic. His peers were aware he had a problem but did not want to report him. The supervisor assessed Mr. Ray, the driver, as fit to drive, possibly because he was short of drivers. Mr. Ray drove the train at speed. Arriving at stations, he left some carriages in the tunnel. He was admonished by the conductor, so he then went very slowly. He admonished again by the conductor, so he went fast, at this time very fast. The conductor did not attempt to stop the train, and the train derailed. So looking at the 7 C's, in this respect, we look at the culture. There was a code of silence amongst the peers, thoughts of loyalty, betrayal. The control, there was lack of effective assessment by the supervisor. Communication, failure of the conductor to radio ahead to stop the train. Configuration, the lack of objective processes to identify intoxication. And coupling and complexity, the speed of the train, jumping the tracks, and the human frailty of the driver who dozed off. The cost errors, antiquated braking and stopping system, unable to cope with a train at very high speed. 5 people killed, 200 injured, and the line was closed in the middle of New York for 3 weeks. And looking at contingency planning, there was lack of CCTV monitoring the driver, no objective testing or medical fitness tests, and a poor automatic braking system. So looking at this interaction of factors or events, often the accumulation of factors and their interaction results in a calamity. Small factors are more difficult to identify or quantify, but they often accumulate or fester. One factor could be alcohol or drug abuse. Let's do some definitions. Simple definitions. Hazard, anything that can cause harm. A risk is the probability of the hazard causing harm. I'll give you an example. A simple example, there's a pavement, there's a lamppost, and there's a 20-year-old texting away. He gets to the lamppost, he carries on texting. He doesn't look up at all. But if he's intoxicated, his peripheral vision is dramatically reduced. He'll hit the lamppost. So looking at alcohol and drug abuse as a hazard, we can probably say yes, it can be a hazard, because it can cause risks to the environment, risks to the general public, risks to employees, risks to the employer and the business, such as vicarious liability, etc. And this leads us then into looking at risk assessment. Now, the Health and Safety Executive, I hope you've all heard about the Health and Safety Executive, describes 5 steps to do a risk assessment. 1, identify hazard. 2, identify who may be harmed. 3, assess the risks and action them, and then document and review. But corporate risks are more than that, more than health and safety. It deals with finance, it deals with fraud, it deals with many other factors which could affect the organization. So let's look at the corporate risk assessment. And it's basically made up of 2 factors: risk estimation and risk evaluation. If we look at risk estimation, or what can go wrong, we're looking at the probability of it happening. In this case, in the subway train crash, the probability was hopefully low. But the magnitude, if it happened, was very high. And then you look at the risk evaluation, the impact and the cost. The public perception. What does the public feel? The economic impact. The subway was closed for 3 weeks. The social impact, 5 people killed, 200 injured. And the liability factors, the direct liability factor and the vicarious liability. So risk assessment leads on to managing the risk, which is the second part of my discussion. But let's look at the perception of the risk, the public. If the organization and the employer, if the organization does not recognize that a risk exists, then it's unlikely that any policy or procedures to deal with it will exist. Unless we have an event to anchor our concerns, it's often difficult to accept that the worst can happen. The New York subway crash had a major social and economic impact. Public perception of a problem of a risk went from low to high. So the hazard of alcohol and drug abuse will only be considered by an organization when a risk estimation has been completed, or when a serious or catastrophic event due to intoxication or addiction has occurred. So let's look at risk estimation. And each organization has unique risks, unique to that particular organization. So we've got to look at the type of organization, the type of hazard that organization will have and its implications, the employee population. What is the employee population made up of? The work environment, which may be conducive to alcohol and drugs, and the geographical location, which area of the country it's in, which country it's in, and the cultural and social pressures which play a major part. So looking at the type of organizations, as some examples, I've put in financial sector, trading, banking, investment, insurance, transport, shipping, trains, airlines, haulage. And remember that the internet and transport, without them, globalization wouldn't exist. Looking at the health sector, manufacturing of dangerous substances, we've talked about the chemicals, the Bhopal incident, communication technology, construction, engineering and mining, where there's a lot of accidents and there has been significant problems with alcohol and drugs, leisure and tourism, breweries and distilleries, as some examples. The probability and the magnitude will differ in each type of organization. As an example, I'm going to use a group of companies where alcohol and drugs are unlikely to be a health and safety issue, and a group of companies where alcohol and drug problems are likely to be associated with health and safety.
So we'll start off with the finance sector. I've got 4 examples in the top here. I'm not going to go into them in detail, but all these cases were intoxication, whether it's drugs or alcohol, in the work environment, and these individuals were banned by the FSA. The FSA is indirectly looking after your money. Nick Leeson in his book describes the impact of the binging culture. And interestingly, Bernie Madoff had so much cocaine in his office, it was dubbed the North Pole. But what I want to finally look at is the insurance industry, which has been in the news recently. The Sunday Times business section talked about Lloyd's to tackle the laddish culture. The BBC mentioned Lloyd's calls time on drink and drugs. And what the BBC continued to say is now anyone deemed under the influence of alcohol or drugs will be barred from the building. Security guards will have the right to confiscate passes of anyone breaching the new rule. But I asked the question, how would the security guards know they are intoxicated? Let's look at some examples in shipping. Exxon Valdez was the environmental disaster when it went aground in Alaska. The captain was intoxicated. And if we do look at some of the 7 C's, the culture, the captain was sleeping off a binge. Control, there was lack of control by the third mate maneuvering around icebergs. Communication, the radar system wasn't working and no communication between the medical assessments of the crew and management. Cost for errors, radar was not repaired, it was too costly and complex in short period of time before they left harbour. And contingency planning, medical assessments were not robust, nor communicated to management. And this one actually I picked up in February 2019. A Russian captain drunk as the ship hits a bridge in South Korea. It was interesting watching the video of this. He gouged 10 meters out of the bridge. But those of you who possibly live in Scotland might want to know that previously Grangemouth, as I mentioned, had a problem in this slide. Russian ship 2008 found intoxicated. The captain was found intoxicated on board an oil tanker before leaving Grangemouth on the Firth of Forth, and it was Scotland's only oil refinery and had 10,000 tons of black fuel oil. What I need to say is Grangemouth is in the Firth of Forth near Edinburgh, and to get from Grangemouth out to the open sea, they've got to pass, I think it's 3 bridges, so it's worth thinking about. Let's look at trains. Tadworth Corner Station office was demolished by an intoxicated driver in 1993 when the train didn't stop. We talked about the USA, the subway crash, and tube train drivers have found intoxicated in 2014, 15, and 16. Let's look at airlines. In February 2019, staff members smelling alcohol on the breath of the captain reported the captain, and he was arrested. In India in February 2019, a captain was smelling of alcohol and displayed signs of significant intoxication. He was 10 times over the legal limit for pilots in the UK. Now the level for pilots in the UK is 0.04 grams per cent. He was 0.4 grams per cent. That's equivalent of 400 milligrams per 100 mil, and he was about to fly a plane. In Japan, there's been repeated pilot intoxication identified from 2009 with no intoxication legislation for pilots. That's only been introduced in December 2018. And in 2016, a pilot landed at Norwich Airport with 3 times the legal limit to fly a plane. So, what is the public perception? The Daily Mirror in 2016 said the flight industry has been hit by a series of pilot scandals involving alcohol. But what one airline then did they stopped using the word intoxication or arrest, and they declared that the pilot was incapacitated due to the physiological inability for a pilot to perform their normal duties. So what do they mean by physiological problems? Let's look at these in detail. You've got the eye-hand coordination is slower, precision in manipulation is reduced, slowing of reaction time, reduced cognitive processing, such as concentration, judgment, but increased risk-taking, and spatial processing was reduced. Now, spatial memory is that part of the memory responsible for recording of information about one's environment and spatial orientation. If you're, for example, dumped in a city that you're aware of, you will find your way home. But I want to talk a bit more, give an example of spatial factors. If we look at the functional MRI scan of two 20-year-old females doing spatial tasks, on the left-hand side, where's my pointer? This one here, you'll see there is a lot of activity in the brain doing these spatial tasks in the frontal and parietal lobes, there and there. But in B, the dependent drinker who is going through a process of withdrawal effects, you'll see there's significantly less activity. So in conclusion, risk assessment. Alcohol and drug abuse may not be perceived as a significant risks to an organization, but they could be a small or significant festering problem. There is often a culture of acceptance or worse, encouragement due to peer pressure. Risk estimation should identify the potential risk to the organization. Risk evaluation should identify the potential cost to the organization. And risk estimation should be an accepted process to identify the potential risks to help formulate an alcohol and drug policy. I'll now hand you over to Sarah.
Thank you. So I don't know how everyone was planning to get home from here, but I suppose we should all probably just walk for fear that the tube and the planes will be disrupted. Lots to think about. What I want to focus on is how an employer might respond to events like Mike has discussed, and what they might be able to do in terms of either disciplining or supporting those employees who may have been affected by alcohol or drug use and abuse, both in the sense of one-off events of intoxication, but also in the sense of ongoing dependency issues. Mike has looked at the sort of disaster situations which obviously cause huge effects for the employer in terms of risk and PR disaster and those kind of things. I'm going to look at some of the more subtle risks, if you like, that an employer might face, really focusing on what sort of legal risks they might encounter. And the first thing to think about, and why I put it up here at the beginning, is really to set the scene going forward for something that an employer must always bear in mind, and also someone who is looking after an employee or advising an employee who is involved in a situation where they may have a drug or alcohol dependency or may have been intoxicated at work. And it's that of disability discrimination. So in the UK, we have a law called the Equality Act 2010, which effectively reformulated much of the legislation which has existed since sort of the mid-1990s. Much of that comes from Europe. So if you also practice in the EU, a lot of what I will say will be equally applicable throughout the EU in terms of discrimination law. The law is quite different in the US, and I know that the way that they view addiction in particular differs under their discrimination legislation. So what I will say is specific about the UK, but more broadly similar in the EU. And the reason I kind of want to talk about it first is because it's really important if you are responding to any situation in the workplace as an employer, or if you're helping an employee, to know first of all what protections that individual has. If you're the employer, you need to know what you can and can't do with regard to that individual. And if you're looking after the individual, you need to know what rights and remedies they might have available to them and what they're entitled to. And where I start with that is disability, and it's whether that person is disabled under the law in the UK. And it surprises some people that, in fact, someone who has an addiction, and the law defines that as including a dependency, is specifically excluded from disability protection. So in theory, an employer could dismiss someone because they have an addiction, and that person doesn't have any discrimination remedy. But it's not quite as straightforward as that. I've popped the definition up there of disability. A lot of people here might also practice in fields of mental health and will be very familiar with that definition. But there are certain circumstances in which disability does still need to be considered when looking at someone who is either intoxicated or has a dependency issue. And those will be mainly fall into two categories. So either where somebody has an addiction which has arisen from a disability, so they may have an underlying mental health problem, and that will frequently be a disability. So just because someone has an addiction or a dependency does not mean you can just write that off and assume you can just do what you want. You need to consider what any underlying issues are. And then kind of the flip side of that is where a disability has arisen from a dependency issue. A really obvious one, and there was a case in which this was held to be a disability, was cirrhosis of the liver, which arose from someone who'd had a long-term alcohol dependency issue, and that was covered by disability discrimination legislation. So there are circumstances in which, even where addiction is an excluded condition, there will be protections. So what I would say to any employer looking at a situation like the ones that Mike has described is, step one is kind of find out what you're dealing with, and that would involve getting expert medical evidence from a doctor to understand what is underlying the behaviour and the potential dependency issues that you might be seeing presented. And so to think about situations in which this kind of comes to life, situations which we see in practice where there are potential issues arising in the workplace which often have underlying causes, either intoxication or dependency, I've put them up on the slide. One I would say is we see a lot of sexual harassment cases, and I would say that Me Too is fueled by alcohol. I'd say in 99% of cases that we deal with, there's an alcohol situation, and actually in quite a large portion of those, when you dig down, there's a sort of stress, alcohol dependency, inappropriate behaviour cycle that we often see. So we frequently see that when we look into a harassment allegation, we will find that in fact that person was drinking quite heavily at the time, but perhaps that person drinks quite heavily frequently, and that person is self-medicating because of the stress of their job. And that uncovers a whole cycle for an employer to think about. So although it might seem quite straightforward to think, well, these things are often caused by the taking of substances or underlying dependency issues, there's often further issues that need to be unravelled when you're looking at these things. It's also important to consider when you're thinking about any situations which involve drug or alcohol taking in the workplace, the extension of the workplace. The workplace is not just when you turn up and you're at your office and you do your job. There is a concept that it is quite widely extended actually beyond that, and we are seeing more and more the courts accepting a lot of circumstances in which perhaps 10 years ago would not have been an extension of the workplace to be an extension of the workplace. So for example, this conference would be an extension of all our workplaces if we've been sort of sent here or supported here by our employers, and you know, the pub after work is a classic extension of the workplace. So if someone is drunk and then fights in the pub after work, then that's probably a workplace issue. So why does it matter? So it matters to both employee and employer because there are some legal issues and risks that arise from the idea of disability discrimination, or if an employer was to ignore these issues and just bulldoze ahead and do something anyway. The risks are in three main categories. There's the legal risks, which would be a claim being brought against the employer, so that would engage the employee and the employer. That claim might be for discrimination, so there might be an underlying disability. That person might be able to show that that has caused the behaviour or that has caused the dismissal and bring a claim. There might be a personal injury issue that reflects both health and safety concerns, and also things like violence in the workplace, where if someone is injured as a result of that, they may have a remedy against the employer. And then there might also be some criminal legal risks there as well. There's no specific obligation in the UK for anybody to report a crime, except for a very small exclusion related to things like terrorism. But you know, if, for example, you witness someone fighting at work, you don't have to report it to the police. But someone might well do that, and that might involve the police and some criminal aspects. There's the business risks, which are fairly obvious around reputation and loss of revenue, loss of productivity, if someone is off sick, or if the conduct is prohibiting them from performing their job properly. And then there's regulatory risks, and we see these quite frequently in regulated sectors like law, medicine, accountancy, where if someone is guilty of misconduct or is incapable of performing their duties for other reasons, they can sometimes lose their right to practice in their chosen career, which can have knock-on devastating effects for their well-being. So thinking about practical steps for an employer to prevent the risks that Mike has spoken about, if we just look at that for a second, prevention is definitely better than sort of retrospective action. We've seen the Lloyd's of London example. We are both quite perplexed by why the security guards have suddenly become experts in diagnosing the level of alcohol in someone's system, but we'll see how that progresses. It actually also applies to visitors, so it's literally around the corner from my office, so I think one day I might just try and get in and see what they think of me. Policies and training are something that any employment lawyer will harp on and on about, but they are really important because they really set the groundwork for both parties, the employer and the employee, as to what's expected and what is expected behaviour and what people should be doing in the workplace and how people should be behaving and what they shouldn't be doing. And it gives the employer a basis for then taking action. If in fact someone does something that they're not meant to do, they can point to a policy and say, well, you knew that that was going to cause you to suffer some sort of disciplinary consequence. So they are important. We are recommending that people really think about social events and the drinking of alcohol at social events to prevent Me Too type harassment. Alcohol consumption, as I say, is a huge contributing factor. Lots of employers have started a designated driver policy where effectively one person at every event who's of a senior level in the business has to refrain from drinking alcohol so that they can police the other people's behaviour. And I've spoken to a few people who've had this unfortunate or fortunate role of designated driver, and they have said, I've had to intervene to stop something happening that was either going to be a fight or going to be a harassment situation. So I think it's probably quite effective. Some companies are having a complete blanket ban on alcohol at every work-related event, which might seem extreme, but I think it's probably what's coming down the line because we do see it causing so many problems. And I think in the US in particular, in such litigious culture, that's where some of the alcohol bans are coming from. And I think that will gradually migrate across the pond. And then there's if you can't prevent it, then what do you do once these situations have arisen? So I think one of the first things to do is, I put there up the question of disability. Establish if that person has a disability. It may not mean as an employer that that person might not be able to be sanctioned, but it is vitally important to know what you're dealing with and to get medical evidence and medical help to understand. And the other thing I would say is that it's also really important because when someone's facing some sort of disciplinary conduct allegation, that can be incredibly stressful. And if that person is already suffering from a mental health issue and has maybe had some problems with sort of dealing with these issues in the past, then you could tip them over the edge. And we've had a couple of really distressing situations in the legal sector recently where people have been accused of sexual harassment, and in one really sad situation, the person drove to a cliff and jumped off and took his own life. So it's really important to not just understand it from your pure legal risk perspective, but also from the ability then to support that person appropriately when you are engaging them in a process in the workplace. And then one thing which we'll come on to discuss in more detail is to try and understand at the beginning of any situation that's presented to the employer, is that a medical situation or a conduct situation? So that's something that's really important to understand. And typically, although not exclusively, we see situations of one-off intoxication being conduct issues and situations of dependency and ongoing performance issues arising from that as a medical performance issue rather than a conduct issue. And that flows into the next point, which is just that you've got to make this decision as an employer. What does the employer want to do? Does it want to support people on a road to recovery, or does it want to sort of sanction every sort of minor misdemeanor? And particularly in the context of often addiction not being protected by the Equality Act, and therefore, in fact, an employer could just take a very hardline approach. But an employer really needs to be thinking about what they want to achieve. And I suppose from a medical perspective, I would think about when being asked to report to employers and to employers' solicitors advising, don't be scared to make suggestions as to what you think would be the best thing to do, because actually that might be enough to swing the balance for an employer to, not sanction someone and to support someone instead. So that brings us on then to that issue of intoxication versus dependency. So although this talk deals quite broadly with a number of potential different situations, they do tend to fall into two situations that we see in practice. And those situations are quite different and difficult to deal with. As I flagged, conduct tends to be related to intoxication. So the classic one that I used to get a lot of questions, an employee turns up to work actually drunk or off their head on drugs. So I had a factory where there was a lot of very dangerous cutting equipment, and the client phoned me up one morning and said, one of my employees has turned up to work under the influence of cannabis. What do I do? And so there's an immediate problem there of what do you do right there in the moment? Well, you need to get that person out of the workplace before you make any decisions, because that person is a risk to themselves, a risk to the other people that they work with. So that's usually a conduct issue. And then there's a performance issue. So that's the issue of where someone often will have an ongoing dependency. It might not be apparent to the employer, but what will trigger in the employer's mind is that this person's just not performing at their normal level. They're getting things wrong. They're maybe turning up to work a little bit late. There's maybe some infrequent absences. Perhaps their attention to detail is a bit off compared to usual. And these are all red flags for performance issues. And what would tend to happen is that the employer would then instigate a performance process with that employee. And hopefully in the context of that process, it would become apparent that there was a medical issue, a dependency issue. And then through that, they would then do that research into whether there was an underlying disability and what support needs to be put in place for that employee. When you're looking at conduct, we are looking at things like sanctions and dismissal. An employer needs to make sure before they dismiss, check whether there's any underlying disability that's affected the person's conduct and behaviour, and whether that needs to be borne into the mix. And then they need to think about whether or not a dismissal generally is reasonable. What they don't need to think about is the impact of that dismissal on the employee. So they don't need to think about whether that's going to send that employee into a spiral, in terms of their addiction or their mental well-being, albeit they probably should think about that. But legally, there's no particular obligation beyond a general duty of care that they have to their employees. So looking in a little bit more detail about the intoxication, I mentioned this before. A couple of things I would just say is that even when it's intoxication, it's not clear-cut. Even though it looks like a clear intoxication conduct issue, you do still need to do an investigation if you're an employer, and if you are looking after an employee, you need to push for that if the employer is not doing it. I think there's a tendency with some employers to think, well, this is really straightforward. This person turned up to work drunk. I'm going to sack them. It's not that straightforward. And there are a couple of cases where someone has come to work having perhaps been under the influence or having drunk quite a lot the night before and is incapable of properly performing their duties. And a dismissal in those circumstances has been unfair, even though I think most people might have thought it should have been fair and it was a really obvious situation. An employer has to establish the facts. And from an employee's perspective, it's generally helpful to participate in an investigation. And ACAS, which is the body in the UK which sets out lots of different rules for employers to follow and for employees to get guidance from, which is a government organisation, has set out in their code of practices for discipline and grievances things that they think are important. So what they've said is that consideration should be given to whether to treat drug and alcohol issues as medical rather than disciplinary. So there's no hard and fast rule that it must be treated as medical, but that is quite a clear sense and encouragement from a government body to say, stop and think about this and don't be sort of writing people off and dismissing people who might have a dependency issue, when in fact you should be treating it as in the same way that you would treat any medical issue. And they want people to be encouraged to seek help and treatment. So then turning away from the intoxication issue and thinking about the capability issues of addiction, as I say, it's often a sort of an attendance or performance issue. And again, I would say investigation is paramount. So it's not okay to just say, oh, this person's not performing properly and it's because they've got an addiction, let's just get rid of them. You really need to be seeking medical advice and getting the facts and getting advice from expert physicians, whether that's an occupational health physician or the treating physician as well. And then think about what support you want to put in place for that employee. So specialist guidance, improvement plans for that employee's work, perhaps employee assistance programs will be able to help with the putting in place support packages, and think about whether residential care is also, and residential treatment is also appropriate in the circumstances. Oh, I think this has stopped working. Let me just do. No, I think we've got a frozen computer, unfortunately. Don't know if we've got someone. I will continue old school whilst somebody helps us. It just seems to be, don't know. What I was going to say whilst we get some IT assistance, I should probably just grab this as well, is that there are some complex causes of addiction, and one I flagged earlier is it working? Oh great, thank you, sorry. Is stress at work. So one thing that we frequently see being cited by doctors when we get medical expert opinion is stress at work being a contributing factor for dependency issues, and it comes up frequently for the work that we do, and it's something that an employer then really then has to reflect on what have they done to contribute to the problem, and what support should they have put in place and should they be putting in place to help with the problem, and are there certain things that they should be doing, for example adjusting that person's workload, adjusting the way that that person operates, adjusting where that person works from to help them. There might also be completely unrelated issues. That's not to say the employer shouldn't still support them, but the employer in those contexts probably got less of an obligation to do so. There are certain industries where I think there's a higher risk, for example transient working populations, those sorts of industries, and working patterns. So I grew up in Aberdeen and was very well aware from a young age of the fact that when people come on and off the oil rigs or on and off the boats down at the harbour, they tended to go straight to the pub at 5 in the morning. And I think there's like 3 or 4 pubs in Aberdeen where you kind of know that you could 24-hour drinking is perfectly acceptable. It was a massive shock when I came to London and realised they shut at 11. I was didn't know what to do. But yeah, so it highlights that point. Industries themselves, so high stress, high pressure industries, quite often you see people self-medicating stress, and then other industries which have irregular working patterns, perhaps make home life more difficult. We also see an increase in those as well. I've put up there a list of policies. I don't intend to run through them in any detail, but they're important. They set out the expectations of what's expected by everybody in the organisation, including the employer. The only one I want to talk about is the drug and alcohol policy. It will often also be called a substance misuse policy. A lot of UK employers don't have them, most US employers do, and it's usually part of the health and safety toolkit, and it should include the employer's approach so that employees know how they will be dealt with if they have a dependency issue or if they have an intoxication conduct issue before that happens. Those kind of policies don't deal with one-off incidents, they are dealt with by the disciplinary policy. What does that policy contain? It sets out the expectations of the employees. It should be tailored to the industry, so where there's particular health and safety concerns, you might require a stricter policy. And it should be clear about the rules around alcohol consumption. So some employers will have a zero tolerance approach. Some employers will say, well, at events you may drink, and that's absolutely fine. But it's important to have it set out and clearly set out so that people don't inadvertently fall foul of the rules. Employers should think about prescribed medication, and again that's something where sometimes expert medical opinion will need to come into the mix, because there will be situations in which prescribed medication will have an impact on someone's ability to do their job, but it's obviously not a dependency in the way that it's excluded from the equalities legislation. And then employers should also think about in that policy how they will deal with these addiction dependency issues. So will they adjust duties during the treatment period, and how much involvement will they have from the doctor? And then the drug and alcohol policy will usually deal with the issue of screening and drug testing, which we'll talk about in more detail later. And then on that note, I'm going to hand back to Mike and hope that the computer holds up.
Thank you.
Following on from Sarah, I wanted to talk. I've talked about risk assessment in the first part, And now I want to talk about how you manage that risk. And again, as Sarah's mentioned about the policy development, I think I won't go into any details about the policy, but implementation needs to be well planned, as it may impact on many different cultures and habits already embedded in that organization. There needs to be an emphasis of a caring, supportive culture for dependency, which will help bring employees on board. With only a disciplinary approach, as Sarah's mentioned, this can make employees hostile as it induces anxiety. Then we look at the procedures and protocols which are lying below the policy statements, which need to be robust, they need to be well followed, and they need to be well documented. And then we come to the education, which again Sarah mentioned, how important it is, but also how important it is to change the culture of the organization. Management should be able to identify, act, educate, and care. Employees need to understand the impact of alcohol or drug abuse on their work environment. So looking at the caring approach, which I want to emphasize, we need to separate intoxication at work from dependency, and therefore that lets employees feel safe to seek support for dependency. And the corporate culture needs to change so that it can be made to provide positive reinforcement to seek help. But how do you separate intoxication at work and dependency? We can look at the Lloyd's case and the security guards. Well, good few years ago, I worked in South Africa, and I worked in a company where there was a significant alcohol problem. And it was so bad that actually at one point, there was 2 fatal accidents. And post-mortem, the blood alcohol levels were 3 or 4 times the intoxication level. And the Department of Manpower, which is the equivalent of the Health and Safety Executive in South Africa, said that if the company didn't sort this problem out within 1 month, they would shut the plant down. So they came to me and said, help. And I said, in the short term, all you can do at this stage is introduce random breathalyzing at the gates. And this they did. They implemented this random breathalyzing. And what was interesting, in the first month of doing this, there was 10% of those coming through the gate randomly chosen would be defined as intoxicated, randomly chosen. 40% of those randomly chosen had alcohol in their system when they came to work. So as you can see, there was a significant problem. This came down quite dramatically. But one of the interesting things I want to show you is that ongoing over time, those who were late for work was quite significantly high. And then when the breathalyzer was introduced, over a short period of time, it dropped to nothing. But what happened is, absent without leave increased, which actually didn't necessarily change intoxication, but it changed intoxication at work. So the whole process did help as far as the corporate situation was involved. There was another story which I haven't mentioned, a company in South Africa where management, and it was a British company, where management actually were very concerned about what was happening, so they put CCTV cameras on the walls of the plant. And on the night shift, they saw crates of beer coming over the wall into the plant rather than out of the plant. So there was obviously a factor. But what you're looking at in this case is there was a significant deterrent factor. And So what we need to, just to emphasize what Sarah was saying, the difficulties, if there's complications, particularly from a mental health point of view and a physical point of view. So coexisting medical conditions such as liver disease, cirrhosis, cardiac or cognitive impairment, and a dual diagnosis effect, such as bipolar, ADHD, schizophrenia, and personality disorders. And just to emphasize what Sarah said, dependence with these medical problems and the physiological damage due to dependence may constitute disability under the Equality Act, even though addiction on its own does not fall under the Equality Act. And then we need to talk about the diagnosis of intoxication. There's the ambiguity of the diagnosis in the early stages, particularly around dependency as well. The manager is the responsible person. The manager is the person who decides. He has the ultimate decision whether that individual is fit to work. And this uncertainty of diagnosis is unavoidable without all the facts. And therefore, I always say that documentation is very important. But the majority of cases of intoxication at work are missed if only subjective methods are used. And we consider the Lloyd's process of security guards assessing intoxication. And it's also often difficult to confront someone stating they are intoxicated and should not be at work. It's not easy to identify intoxication at work. And so I want to now talk about a subject, a survey that was done with 1,000 drink drivers who were actually had blood alcohols done, and then they were individually, subjectively assessed by independent doctors to look at what their subjective assessment came up with, whether they were intoxicated or not. And as you see on this graph, at 100 milligrams per 100 mil, or 0.1 gram percent, only 20% were identified. 80% were not identified. And even at 0.4 or 400 milligrams per 100 mil, 5% were not identified. But what is interesting is if you look at the red line, which goes to 80 milligrams per 100 mil, which is equating to intoxicated at driving in the UK, and the graph itself, all those in this area here would be considered as falling, would be considered as having tolerance. And the tolerance factor would be one of the indicators, I would believe, of dependency. There's another factor called the Mellenby effect, which is also got to be taken in consideration, which is called acute tolerance. And that is when the ascending level of the blood alcohol, they subjectively feel intoxicated, but on the descending level, at the same level of blood alcohol, they less feel intoxicated, but their disability, of their ability to function is reduced considerably. So I want you to look at the iceberg, bringing back to the iceberg scenario again. There is a continuation of a use and abuse, and there are 4 standards I'm looking at: the hazardous drinker, the harmful drinker, moderately dependent, and severely dependent. All have the potential for intoxication at work. But the harmful drinker and the hazardous drinker, with an objective measurements, will be able to manage and be able to be supported by the deterrent factor in this case. So looking at identification of alcohol, briefly I want to talk, we've talked about a subjective assessment. It's difficult, it's not viable in the workplace except as a deterrent because there's too many false negatives. Objective testing is broken down into direct objective alcohol testing or drug testing such as breath, blood, urine, saliva. Indirect objective testing are biochemical tests such as blood tests, again, hair and saliva, which is the effect on the body, not the direct measurement. And then there's questionnaires. And I would state that the validity of is questionable in the workplace if there is poor trust between management and employees. And then there is some non-biological testing, such as the eye check pupillometer and the Stroop test, which could be of value if further developed. And then looking at identification of the dependence factors, and Sarah has mentioned some of these, on-the-job absenteeism, presenteeism, where the individual is at work but they're not functioning effectively, recurring short-term sickness absence and absent without leave, we've discussed, subjective clinical signs, progressive deteriorating work performance and poor behavior at work, and a history of accidents. So looking at, summing up on this factor, we need to differentiate between intoxication at work and alcohol and drug dependency. Intoxication at work is misconduct, and dependency should be discussed, considered a medical condition and capability. And the policy needs to recognize dependency as an illness and to promote a caring approach. Alcohol and drug dependency possibly could be considered as a disability under the Equality Act under certain circumstances. I'll now hand you back to Sarah.
I just to say one thing actually which occurred to me as Mike was speaking, which is that it's one thing that is a disability, that can be a disability under the Equality Act, but which kind of goes contrary to what I said earlier, is where the drug dependency has arisen out of originally prescribed drugs prescribed by a doctor. So if someone has an opioid addiction, for example, that may be a disability. We really quickly wanted to cover the drug and alcohol testing or screening, and also then finishing off just on a couple of slides about what employers can do to support people back into the workplace if they've been off for a period, often as a result of some sort of dependency, and potentially they've been in inpatient treatment. So on the drug testing, it's not very common in the UK. It's more common in the US. If an employer wants to do it, they need the explicit consent of the employee. And they should have a policy which sets out when it will be used and why and what will be done with the data. If you have a policy that says that someone might be subjected to drug or alcohol testing, what does the employer do if someone refuses to take a test, as is their legal right? Because their consent, even if they give it for regular testing, can be withdrawn at any time. And even if they give it for a one-off test, they can withdraw that consent. That's the employee's fundamental right. And therefore, what does the employer do if the person refuses to take the test? So they may be able to institute some disciplinary sanctions, disciplinary investigations in that context. But they need to consider, was it reasonable in the first place to expect that person to subject themselves to a test? And there are very few circumstances in which it will be reasonable. It will be reasonable, at the bottom there we've got where there are specific health and safety concerns or a serious damage to reputation. I'm just going to put up there on the slide what the Information Commissioner thinks about it, which is essentially that there will be very few circumstances in which it will be reasonable. So then we want to just talk very quickly, sort of 1 minute, on supporting people back into work. I know we're just at time. I think we also started a little bit late, which is why we're a couple of minutes running on. But all I really wanted to say is that the employer will need to establish the medical position and then work with occupational health and the treating physician to establish a proper protocol to get someone back into the workplace, so that there's a limiting the likelihood of relapse. And then Mike's just going to finish up.
Thanks. So finally, I want to talk about rehabilitation back into the workplace, which is one of the factors which is often forgotten about. Very few companies actually do an effective rehabilitation back to work. And I'd say there are 3 stages here. Stage 1 is a clinical assessment. Stage 2, risk assessment, meeting between management and occupational health for fitness to work. And stage 3, a return to work with monitoring and review. So stage 1 briefly is the assessment by occupational health prior to returning to work. Needs to be a required discharge report from the rehabilitation clinic or alcohol and drug team. Maybe needed a psychiatric report. And then we come to what should be done is, I believe, baseline tests to see where the level is of that individual. And that is taken as the baseline from ongoing monitoring. And then secondary complications and dual pathology considered under the Disability Act if that's appropriate. And then stage 2 is the actual return to work assessment with advice from occupational health. The manager plans a phased return to work and capability route is instituted with human resources. and in some cases a corporate policy with an embedded contract for the individual to sign. We call the constructive persuasive approach. And I'd just like to ask Sarah briefly about this, what she feels about the contract signing of an individual who's going through the process of returning to work and rehabilitation.
I think that, as I mentioned, even if someone signs a contract, they could withdraw the consent to any sort of testing that might be set out in that contract at any point. So in fact, it's maybe valuable to sort of encourage adherence, but it's not going to be absolutely categoric.
Thanks. And then finally, the risk assessment process assesses the safety implications and the organizational risks. So the risk assessment, I won't go through in detail now, but we've got to consider things like close supervision, public contact, driving, moving machinery, and decision making, such as in the financial and market sector, which is something which needs to be taken in very much into consideration. And finally, stage 3 is a return to work with monitoring and review, the phased return to work with ongoing risk assessments, monitoring up to 2 years, and again, I'm mentioning the objective blood, urine, breath tests, monthly for 6 months I would recommend, then 3 monthly for 1 year, then annually. And I always say 2 obligatory rules. Don't attend work if you've relapsed, and inform occupational health if you have relapsed. And why is this? Because I believe it's a powerful tool to address any lingering denial, and you're able to use the relapse as a reinforcement in further therapy. There's a summary, which I won't go through because we're over time, and